Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I am your host. Today in the studio, we have Rob Ambrosino. Now, Rob grew up near Pittsburgh, Pennsylvania. He earned a scholarship to Texas Tech University School of Law in Lubbock and attended from 2005 through 2008. There he met his wife, Tracy, who was also attending Texas Tech as an undergrad. Her being from San Antonio ended up bringing Rob back here after law school. Rob's first job was in San Antonio and with the civil rights firm of Van Oss and Associates. David Van Oss has recently passed, but he did run for Texas Attorney General and the Supreme Court in the early 2000s. David actually introduced Rob to me as he opened up his own criminal defense practice in 2009. He's practiced here and in over 30 counties in Texas. Rob was named a Super Lawyer Rising Star for 6 consecutive years from 2018 through 2023 and has been recognized by San Antonio Magazine and seen in San Antonio Magazine for excellence in criminal defense. Welcome, Rob.
Thank you, Judge. Thank you for having me.
Rob, I appreciate you being here.
Absolutely. I really appreciate the opportunity.
All right, so let's talk a couple of things that are very significant with your bio. You worked with David Van Oss. He was a really, really good friend of mine. He recently passed. I still keep in contact with his lovely wife, Rachel. Just good people. Those are good people to start your career with.
Absolutely. Yeah. David was a great attorney to start with. Tenacious attitude. Most definitely wanted to help people. He wanted to help all sorts of people from all walks of life.
Yeah, he ran for the Texas Supreme Court. I think he ran for Texas AG. He ran for statewide offices, which in Texas is virtually impossible or has been impossible in the last several years for a Democrat to win. What are some of the things that you got from David? What kind of a David Van Oss story do you have for us?
Well, to be honest, David was so busy and stretched so thin. So he wasn't in the courtroom a whole lot, but we did talk a lot. He did teach me a lot. I actually did a criminal trial with David for a Class C misdemeanor that was kind of a friend of his. And I learned a lot in that trial. And I think David did too, because he didn't really do a lot of criminal. It's a good learning experience for both.
But you were the criminal guy for him.
Well, I became the criminal guy. To be honest, David had some cases that he was working on at the time that he assigned me to primarily that involved the Bexar County Probation Department, civil rights cases. And so he had me working on those. And that's mainly what I did my time with him. And so as a result of doing that, I spent some time at the criminal courthouse sort of researching different issues, pulling files, and I got to meet some people. And then I determined that I think criminal defense would be a good fit for me. I had a little bit of experience with it in law school, but then once I got here, I got to be in court and kind of participate in some of those proceedings. It really was something that I took a light to.
It's interesting how we tend to fall into our careers, right? With David, when I first got elected in 2008, I was blessed to get the endorsement of a lot of different organizations. And one of them was the Probation Officers Union, and David was representing them through some difficult times for that union. When I met him, he immediately wanted to talk to me about how serious I was and being a person who sat on the bench for the people. And so he always had that concern about those that are less fortunate than us, those that need a helping hand, those that really need the system to work with their behalf. And so kudos to you.
That's exactly David to the T. I mean, I couldn't describe him any better than that. You understand about falling into careers. So when my wife basically told us that, hey, we're moving to San Antonio now, it'd be kind of during the Great Recession, I guess is what they call it. And the DA's office was going through a hiring freeze. If I wanted to get into the criminal world, a lot of young lawyers starting the DA's office and they kind of migrate from there. But I basically had to hit the ground running doing misdemeanor court appointments and then eventually felony court appointments. And that was a tough couple of first years, but eventually I got the hang of it.
Well, I know you've had a lot of cases. I've seen you in the courthouse for a long time. I used to live in Helotes, right? That's where I raised my family, and I would see you over at the gym. We got to talk a lot. I'd see you in court, and I know that you've had a lot of success in the courtroom. And is that sort of how you fell into the idea of working with expunctions and non-disclosures?
Well, it kind of ties into a lot of things that I've done over the years. So I had some experience in civil law, with David. And so whenever I got into criminal world and I started, getting cases dismissed, a lot of times with court appointments, right? You would get the case dismissed. Court appointed client that you may have would follow up with you and say, hey, how do I get this off my record? Is this just going to follow up on my record automatically? Right. And that's actually a very common call that I even get today. People think it's just going to automatically follow up their record. Basically, I started to research it, and exceptions themselves are more of a civil procedure. And so I think I was kind of at home there, especially when I was, a young lawyer. And so I didn't have any problem, getting into that while I was building my criminal defense practice. So it's something that I just kind of taught myself and build up a big part of my practice over the years there.
Well, let's talk about expunctions. What exactly is an expunction?
Yes, absolutely. Great question. Obviously, a great place to start. The Code of Criminal Procedure defines an expunction as obliterating the file. I think that's a great word. I think that's a word that we don't use much in society, but I think that explains it well. So if the case is dismissed, you're found not guilty, the arrest records get destroyed, theoretically. Shred of evidence showing that you were arrested, the police reports, the record of the court case is supposed to be completely wiped off the face of the earth, and you're supposed to be able to deny that it ever happened.
Yeah. I didn't know that the Code of Criminal Procedure used that word.
I was actually very surprised to look it up and see the exact language that they had used. And you're usually not very artful in your language, but this definitely works. So kudos.
So the case, in order to get an expunction, the case must be dismissed on its face. Is that right?
Yeah. So if you're acquitted at trial, you can also get an expunction that way. Process, I'm sure you deal with that pretty regularly, Judge. Whenever anyone's not guilty in your court, usually the defense attorney can just bring a pretty brief 1 or 2 page order to you saying that the case is expunged. And if they do that within 30 days, I don't think they pay filing fees, and it's relatively simple.
Mm-hmm. And so for that kind of a dismissal / expunction, if it's in a misdemeanor court, it would have to go to a district court.
That's right.
Right. So I do get a lot of folks that come in that had a misdemeanor jury trial, and defense attorney says, we got a not guilty. It's been signed by the state as well as myself. So it's basically just a matter of me signing that document, sort of an automatic when it's presented in that sense. And then the case is dismissed and then expunged.
Right. That's the closest we get to an automatic expunction. But that defense attorney has to take that extra step. That situation happening where they don't follow up. And then they still have the ability to have it expunged in a more traditional way, but as I'll explain, does take a lot more effort and costs a lot more.
What we're talking about here are cases that can result in jail time, which is a Class B misdemeanor on up, including every felony offense that somebody can be charged with. But it can also happen on a Class C misdemeanor.
Yes, Judge, a Class C misdemeanor can also be expunged. Basically, the way that many Class C misdemeanors are resolved, and good examples of Class C misdemeanors might be theft under $100, possession of drug paraphernalia, a minor in possession. Those cases, if they're resolved with something called deferred disposition, basically usually means you pay a fine, you stay out of trouble for a few months, and the case gets dismissed at the end. Code of Criminal Procedure actually considers that a dismissal, and you can get it expunged. And so really how most Class C misdemeanors come to also be expunged. Now, if it's dismissed in the other way, you could obviously also have it expunged. Like if you go to trial and basically the prosecutor dismissed some day of trial, you can still get expunged as well. But Class C misdemeanors can also be expunged just along as BA itself.
If somebody enters into a plea bargain, let's say on a Class A misdemeanor, whatever that Class A misdemeanor is, the range of punishment in the code says that they could do up to a year in Bexar County Jail locally. In Bexar County, a fine of up to $4,000. They get some plea bargain, or they can do 6 months of deferred adjudication. Is something like that eligible for an expunction?
It's actually not. So if you are given deferred adjudication, that's where the other form of record sealing for adults comes into play, and that's called a non-disclosure. So it's a little bit different. It has different rationale, it's actually a criminal case that it actually goes back to the criminal judge that originally held the case, and it's unfortunately not as good as an expunction. But if you do deferred adjudication, it is all that you're entitled to.
We know that if somebody requests an expunction from a court, it's a result of a dismissal in a criminal charge. And so because it needs to go to a district court, the nature of that changes, right? Once somebody goes through the criminal charge, you get the case dismissed in whatever manner, either through a trial or just a flat out dismissal, or the DA doesn't actually file that case, then the filing of an expunction is actually civil in nature.
It is. Yeah. The way that the code lays it out, basically, you ask the civil court, you file a lawsuit in the civil district clerk where the divorces are filed, where the custody cases are filed, a civil lawsuit to order the criminal courts essentially to obliterate the file.
So we're laying down the foundation here for how expunctions work. There's a lot of situations where somebody is charged with multiple charges or multiple crimes. Let's say in a transaction, somebody commits an assault and then they flee from the police. So then they call that evading arrest. Then when the police arrest them, they resist. So they got three separate charges. What happens a lot of times is plea bargains will be entered where somebody will plead to the highest level, or even sometimes the misdemeanor case, and the other cases will be dismissed. We call that, in our parlance, taking something into consideration. So somebody is pleading to a case, and as a result of that, to take it into consideration, the DA is agreeing to dismiss other charges. Are those other charges eligible for an expunction?
Under 1245, the Texas Penal Code, it says that if you admit guilt to another charge that arose out of the same criminal transaction, then the court would essentially dismiss the case at that time when you pleaded the other charge. It does happen a lot. It's used across the state. I see it in every county that I've practiced. That's probably where the most litigation over expunctions exists, essentially when they're denied by a judge and then it goes up to appeals. Generally, I guess the short answer is no. I guess, with respect to you plead to one case, the other case is being expunged. Now, there are things the courts look at. Sometimes it determines if the case was actually properly taken into consideration. I actually won a contested expunction here in Bexar County where my client, kind of a similar experience to what you had described. I believe that they had a DWI case, and then they also, they pled on the DWI case, and then they had a felony evading arrest of a vehicle that they were charged with as well. And the evading arrest of the vehicle case was dismissed whenever he took plea on the DWI. And the reason that I was able to successfully argue that the expunction should go through on the felony evading arrest was because the evading arrest was not properly taken into consideration, which we're getting to like technical legal jargon here, but the trial court judge did not make that person take responsibility for it. So it's real little kind of details like that that kind of determine if you're going to be eligible if you have multiple cases. But it is pretty sticky with respect to that.
I don't know how often this applies, but I haven't been in another court in a really, really long time. So thankfully, but judges generally make judges generally force defendants who are entering into a plea bargain accept responsibility and plea on cases that are being dismissed or taken into consideration.
I would say it's about half and half. When I say more recently, I've noticed that this happening more often. Maybe that is the reason. Maybe it's because of some of the case law that's come down that's let some of these expunctions go through, even though maybe they wouldn't be able to go through just on the face of it. So I'd say it's about half and half. That's a big part of the reason. It's sometimes multiple charges or only one can be expunged.
That's interesting. When I was a defense attorney, I never felt comfortable sometimes when judges would force my client to plead to those because sometimes the state is actually saying this is not a case that we can prove in a trial, but rather than take a risk at trial, which every trial is a risk, we'll agree to take that into consideration and dismiss it. So is it better then for a defense attorney to have an argument with the prosecutor that, hey, you dismiss this case first, then the individual will plead? That's something that you've considered?
There is. There's a kind of a number of different ways to attack that. Cases that kind of fall in this kind of limbo with respect to expunctions and non-disclosures. And that's usually cases that have been properly TIC because the case wasn't outright dismissed, but then you also do deferred adjudication on it. So you're not entitled to a non-disclosure because you didn't do deferred adjudication. And you're not entitled to an expunction because the case wasn't properly dismissed in the traditional sense of work. So there's a couple of different ways to handle it. If the prosecutor is willing to write on the dismissal something other than let on another case, in the interest of justice, insufficient evidence. What I have had some individuals that are very concerned with making sure that they're able to get cases sealed after the fact. And sometimes what I've had happen, which is kind of odd, is that maybe they'll have two cases and instead of TIC, one will ask the prosecutor to just allow them to go on deferred adjudication on both, because I know that they go on deferred adjudication and they successfully complete it, that eventually they'll be able to get both of them non-disclosed after.
On occasion, I come across an individual that says, I had a felony charge. It was, 30 years ago. It was a minor drug case, but it was considered to be a state jail felony. I pled on that. I got deferred adjudication. It is so old. I don't even know if anybody could find it anymore. Can I get an expunction with that? What would your response be?
That is a very, very common call that I get. I probably get a call once a week. It might be someone that has a felony conviction. that has completely turned their life around since that date. Maybe this case is like in the early 90s. They've gotten married, they've got kids, they've went to college, they've been very successful, and they just had this one thing that's been following them around. And I'm always, mortified to bring them the bad news that no, unfortunately, there's nothing I can do in that situation. There is nothing in the law that allows you to expunge or non-disclose a felony conviction.
When I was practicing as an attorney, I don't recall when it was. I'm going to say that it was probably the early 2000s. We used to file expunctions on cases where, the state would file the case, we would go to court, they would dismiss it. And then a few months later, we would tell the client, I can file an expunction for you. I charge X amount of dollars. We would file it and then we would get that granted. There was some case that came out in the Texas Supreme Court. It was Justice Jefferson, I think, who wrote the opinion. But it sort of changed the way statute of limitations operates on when you can file an expunction.
Well, so Judge, with any expunction, essentially, basically the case is dismissed, right? And then to have it expunged, you always have to wait for the statute of limitations to run. Well, not always, but in most cases you do. And the reason for that is that most dismissals in criminal cases are without prejudice. And that theoretically the DA could refile. So, you have an assault family violence case, right? That's a misdemeanor. Let's say that happened on January 1st, 2024. Basically, you wouldn't be able to have that expunged until January 1st, 2026. So with all misdemeanors, the statute of limitations is 2 years. With many felonies, it's 3 years. Most drug crimes are 3 years. Then in other felonies, the statute of limitations are obviously older. There's some that are 5, 7, and 10. That usually gets in more to robbery, money laundering, and then obviously sexual assaults and murders. At the end of that, murder actually has no statute of limitations. You could probably do a whole podcast on.
And that's because it's a first-degree felony. The range of punishment is up to life, right? And because there's no statute on filing a murder, you could have cold case murders that are filed 40, 50 years later, or aggravated sexual assault charges of a child, let's say, where a child says, I'm 50 now, but when I was a child, this elderly individual sexually assaulted me. Theoretically, the state could bring that at any time.
Right. That's exactly right. Now, there are some other ways that you can get it expunged. And a lot of times it involves trying to get the prosecutor to agree. And that's never fun. And I mean, it's not up just to be nice to you, just so your client can get this off of their record. So that happens some way. So you can get it expunged if the DA says that they're done with the file and they're not going to be prosecuting the case. I've ever been able to get that done once and not here in Bexar County. So it's pretty infrequent. And then basically if there was some type of identity theft situation, you don't have to wait for the statute in that situation. But obviously that's not very common.
Statute of limitation cases really, based on what you're telling us, only applies on cases where cases are dismissed without prejudice.
Well, I mean, theoretically, I think the statute of limitations applies either way, even if the case wasn't dismissed without prejudice. But I think that's the main rationale they do that at all.
Yeah. So if somebody was charged with a case and let's say turned out that there's some issue with the evidence and the DA says, we're going to dismiss this with prejudice. Does a case like that still have to wait for that statute of limitations to pass?
Well, there's other exceptions that you can use to get the expunction that don't involve the statute of limitations. If you can argue that there was lack of probable cause at the time of the arrest, you don't have to wait for the statute of limitations. And that might be a reason that a case was dismissed with prejudice. And right, it's usually because of, maybe a speedy trial issue or, a suppression issue, something like that. So I think if a suppression issue was granted, that would be a pretty good argument that there was lack of probable cause at the time of the arrest. If you do a pretrial diversion program or veterans court program, you can get it expunged as soon as you're done with it. And then if you're never charged with the crime or where the charge comes late, you can actually get expunged sooner than most cases.
And a pretrial diversion program would exist sort of like in specialty courts. Like, I'm fortunate to run the felony pretrial diversion mental health court. And it's something like that. That's before somebody enters into a plea or before somebody is adjudicated. They go through a term of some supervision. They complete the program. So then the case is dismissed through an agreement with the DA's office. Something like that then is an automatic. They do not have to wait for that statute.
They don't. As soon as they're done with the pretrial diversion, they're eligible to move for expunction. And that's actually something that I argue to clients sometimes when they qualify for pretrial diversion, because usually it's for people that have never been in trouble before, they have no arrests. I'll tell my clients that is a selling point of doing it, is that as soon as you're done with the pretrial diversion, you'll be eligible to seek expunction, rather than if I do get it dismissed at trial, you still may need to wait another year before you can get it expunged.
Well, that makes sense. All right, well, let's do a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome to the Q&A break. We have a question. I have been summoned for jury duty 3 times, and I have yet to get in trouble for not reporting. How do you really prevent people from not showing up? What do you think, Rob?
Well, I think it's their civic duty. If you receive a jury summons, that you should show up. And it's something that we all do. And it's why we don't have the king in this country. We have the jury that helps decide these things and decides if you were guilty or not guilty of a crime. And that's what we have to make our society go.
That's a very interesting question. In Bexar County, we really haven't had issues with not enough people showing up for jury summons. We do have a yield in our conversation with Julieta Schultz, who is the jury bailiff here in Bexar County. Early in the life of this podcast, we talked about the yield and those that show up. Frankly, about 38% of individuals that get summoned actually show up for jury duty and come in. So we take that into consideration when we issue our summons. In Bexar County, we have enough folks that show up to where we don't have to worry necessarily about not having enough people that come into the jury room. But in other counties, they do. And what they have had to do is actually send the sheriff out to go and pick folks up from their place of work, from their home, bring them into the courthouse to force them to do their jury duty. Also, it is a contempt of court if somebody chooses not to exercise that. So there is a certain fine that could be attached for not reporting. However, the judges in Bexar County at this point have decided that's not something we're going to do yet. We're not in that particular situation. And really, I don't think we ever will get that way in Bexar County, because we do have folks that are just as civically minded, Rob, as you are, in the sense that if they get summoned, we know they're going to show up. Nothing makes me feel better than to walk out in that jury room downstairs, to greet the folks that have been summoned, look around and see how full our jury room is. Really, in Bexar County, our jury room isn't big enough to serve all the courts, but it's certainly big enough to fill up when we issue jury summons and want people to come on in. Thanks for asking that question. That's a good one. Keep asking those questions. We enjoy answering them. Let's head back into the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back. I'm here talking with Rob Ambrosino. But what are the advantages of somebody who had a case expunged? What does that allow them to do with that case and for the rest of their lives, basically?
So that's a good question. I'll get a lot of calls and individuals will say, should I do it? Is it worth it? And the answer is always a resounding yes, because under Code of Criminal Procedure 55.3, if you have the case expunged, you can actually deny that you were ever arrested. You can even deny the expunction. So if you're filling out a job application or any type of license application and they say, have you been arrested? You've had no other cases. You can say no, even though you know differently. If you feel fine, legally it allows you to say no. Very helpful, obviously.
And part of the law is if any agency that's got record of that arrest, after it's been expunged, if they somehow or another release that information, that individual or agency could be charged with a Class B misdemeanor.
That's right, Judge. That's under 5504 of the Code of Criminal Procedure. So that's, essentially when I do an expunction for a client, I give them a copy of the order. We serve the agencies that we believe and know have copies of the arrest record. Mm-hmm. But what I tell them is, it's the Wild West out there. I can't prevent everything from ever happening. If there's some random kind of Facebook page or something with a mugshot that comes up after the fact that they just might not be aware of the expunction order, then what you do is you send them a copy of the expunction order and you can actually these two statutes, if you need to.
So once they've been served, if they show any sort of information regarding the arrest, that's a pretty heavy hammer. That's a pretty good protection that somebody who's had a successful expunction can actually see.
Yes.
When you say the Wild West, in my mind, you're talking about things like the internet, right? I mean, I've seen situations where somebody gets arrested, a booking photo gets posted on some website, and then there's all these other websites that get a copy of that photo, send an email that say things like, if you want us to destroy this picture in the database that we run, it's going to cost you $300, right? That's kind of a common thing. Is it possible in your mind to ever completely, understanding that the law says that you can claim that you've never been arrested, is it possible to ever completely wipe out all evidence of an arrest?
It would be pretty challenging, Judge, if I'm being perfectly honest. I'm going to say that you could probably wipe out maybe 98% of it, but maybe always in the back of your mind, just in this day and age, there is a chance that something might come up after the fact. But if it does, you have that order, which is an order to the world to obliterate the file and obliterate their record. records. So it does come up, and you can send them a certified letter with a copy of the order, and they're required by law to remove it. And if not, contempt of court, and it's obviously criminal.
Back in the day when I did expunctions, I remember I would have to serve something like 13 agencies, right? Things like the Department of Public Safety, the District Attorney's Office, the District Clerk's Office, all these agencies that carry record of the arrests, right? The law enforcement agency. How many agencies now do you typically serve that would carry these types of records?
So the minimum is 8, but there is no maximum. I mean, I've seen expunctions. I've done expunctions involving 20 because there's always going to be the standard kind of agencies, and that's the arresting police department, the jail where the person was booked, the DA's office, district county clerk's office, Texas DPS who has basically maintains state arrest histories for individuals, the bond offices who personnel or maybe pretrial services if it was a PR bond, or they had other pretrial reporting conditions. But there's other places that you might consider as well. That might be child protective services if it was a case that involved the child. An employer, I had one recently where I served the school district because my client had worked for a school district, and so I know that they had records of it. Also consider serving the media. If the case had 12 of the story, then technically you could serve them. Now, whenever you serve them with the petition, they have the ability to respond and then file an answer, and then technically they could object, or maybe the court might only grant the expunction order with respect to certain agencies, not others. But I will say that happens pretty infrequently.
What exactly would a successful non-disclosure allow a client to do? In other words, would they have to explain that particular case to a potential employer? Would something like that come up? And is it sealed from basically all of society the way an expunction is?
So the file is not obliterated in the same way with a non-disclosure as it is in an expunction, unfortunately. But it is still worth it, in my opinion. The government code section 411-0755 says that a person who has a case non-disclosed is not required in any application for employment information or licensing to the state to disclose it. So if you're filling out a job application and they say, have you been arrested? You can actually say no, even though, again, it might feel like you're lying, but legally you're allowed to do that. However, I guess that the caveat about that is that there's 32 Texas agencies under the law that can still see the case under a non-disclosure. And that includes the Board of Texas Educators, who obviously licensed teachers, the medical board, the Board of Law Examiners, just the licensed lawyers, nursing, realty, accountancy boards, all the professional licensing agencies in Texas can still see the non-disclosure in addition to you yourself that, ask the non-disclosure. And then law enforcement can still see a case that's non-disclosed, overly non-disclosure.
That's a good answer. So then if somebody gets rearrested and they had a case that was sealed through a non-disclosure, the arresting agency, the DA's office, public defender's office, the court, the clerks, all of those individuals would see them because it's a case involving the criminal justice system. So then true non-disclosure wouldn't apply in that situation.
Well, I think the non-disclosure has a little bit more teeth than that. Bexar County has a search system where you can search your criminal history or anybody's criminal history. It's public. It's search.bear.org. Have a case expunged, it comes off that system. If you have a case non-disclosed, it comes off that system as well.
Okay.
I think it's just the law enforcement agencies in particular that can still kind of see it in their private histories. And I want to say with the clerk's offices and their computers, maybe the case might show, but it'll show as sealed and they can't see anything unless there's basically an order to unseal.
Now, there are some cases where prosecution office can use a prior deferred adjudication to enhance a charge if somebody picks up the same type of case. And I'll give you an example. Let's say somebody had assault family violence class A misdemeanor a long time ago. They successfully completed deferred adjudication, so there the case has been dismissed. Let's say somebody successfully does a non-disclosure with that charge. Then they pick up a new case in the future. Would that prior case that has now been sealed be used to enhance the new charge to a third-degree felony?
So in that particular situation, you generally can't have assault family violence cases non-disclosed. So there would be no way for them to have it sealed or non-disclosed. So, and that was one of the big problems that people have and why I get some late calls. So it wouldn't really have any effect in that situation.
So assault family violence charges aren't eligible for a non-disclosure if somebody got deferred adjudication.
That's right. And not only on the assault family violence charge, basically any other charge that you've ever had. So if you, let's say you had a shoplifting case that you did a deferred adjudication on 10 years ago, and then 5 years ago, you had an assault family violence that you did a deferred adjudication on. You won't be able to go back now and have that theft case sealed because you did a deferred adjudication on a family violence charge, and that makes you ineligible for any type of non-disclosure.
Okay. Are assault, family violence the only types of cases where that would apply?
No, there's some other charges as well. They tend to be pretty serious cases, murder, sexual assault, things along those lines.
Mm-hmm. All right, let's talk about the process a little bit. Let's say somebody comes into your office, they have a case that they believe would qualify to have their case obliterated within each of the systems that carry it. They want you to file an expunction for them. How does that work?
So basically, the process takes about 30 to 45 days. I have to file, like I said, a civil lawsuit. You have to pay filing fees, which are not inconsequential. They're close to $500 in Bexar County. In other counties, they can be more because the district clerk's office also requires you to pay money to serve all of those agencies. So the more agencies that you serve, the more filing fees there will be because they have to serve all those agencies.
So there's a fee for each agency to get served.
Yes, unfortunately. Yeah. And sometimes that's a cost consideration client will need to make, and I'll explain that to them up front.
How much does it cost to file an expunction?
It's usually about $500 total, kind of the minimum 8 agencies. And then after that, it's another $15 per agency. But in Bexar County, that's about.
So that's before you get to the actual attorney's fees portion of that.
That's right. It is not cheap.
Yeah. So, and I remember people would tell me that, right? I would tell them it costs this much to file. Then I'd give them the fee, which would include that filing fee. And then people would say, hold on a second. You told me you were charging X. And it's like, yeah, but a lot of that does not go to me. That's something that must be paid when you file the case.
Right.
So somebody comes in, they ask you to file an expunction, you explain all that to them, and then you file it. Is there a court hearing that's involved? Does somebody have to go to court to get that proven up?
Sure. So good question. So usually whenever I file it, you have to give all the other agencies at least 30 days notice. Usually you give them a little bit more than that. And a lot of times that's to do with court's calendar. I know in Bexar County, they do the expunctions every Thursday afternoon. So from the day you file it, it might be 5-6 weeks from there that it's set for a final hearing. At that hearing, between the time that you filed it and that hearing, the agencies had the opportunity to file an answer or response to your expunction. And a lot of times they don't. A lot of times they just kind of default. And a lot of the kind of more local agencies, the jail, the clerk's offices, anything that's tied into law enforcement, they usually just kind of defer to the DA's office and how they.
Are judges likely to grant those? Do judges ask questions? What's their involvement as it relates to the hearing to get something like that's obliterated?
So normally the DA's office will agree to most of them. Under the law, there's really not a carve out for the DA to oppose the expunction if you meet the requirements. And likewise, if the judge believes you've checked all the boxes, technically you're supposed to get it. There's not some type of provision in the interest of justice. If we don't believe that you deserve it, we're going to oppose it. So I'd say that, probably 95% of expunctions the DA does agree to, especially if you have an experienced attorney, to make sure that you are qualified for it whenever they filed it, because they know that you qualified for it and they really don't have a good reason to object.
So there are other agencies then, right, that may ask in the future. Let's say somebody applies for a job. You've had a successful expunction. You want to get a job with the government. You want to get a job with the school district. You want to get a job with a corporate entity. What's the likelihood that organization will know that you had a prior arrest if it has already been expunged?
So here's another kind of minor issue with the expunctions is it's kind of hard to tell how long from the time the order gets signed until you can be sure that it's removed. What I tell my clients is that the gears of bureaucracy burn slowly. I can't tell you how long it's going to take for DPS to get rid of all their records and then essentially reach out to any agency that they had sold history to and make sure that they get rid of their records. And again, going back to the internet, it is the Wild West. I usually tell my clients maybe 6 months from the time the order is signed. You can be pretty confident that maybe it's not going to show up. But again, if it does, then that's the recourse that you have is to provide a copy of the expunction.
Well, that's expunctions. And I think we got a pretty good understanding as to how those work. Let's say somebody does not completely qualify for an expunction, but they could qualify to have a non-disclosure. What is a non-disclosure and how does it compare to an expunction?
So yes, Judge, as you obviously know, a non-disclosure is different than an expunction because a non-disclosure generally requires you to have completed deferred adjudication. And what deferred adjudication is a type of probation where in the beginning of it, you might plead guilty or no contest. And if you complete it successfully, at the end of the probation, the case is ultimately dismissed. And then usually, depending on what happens, there might be a waiting period or there might not, depending on the severity of the charge.
So when you say case is ultimately dismissed, I'm sure clients say, hey, case was dismissed, right? Because I've had defendants in court I ask them, I say, have you ever been arrested? They'll say no. And then I'll look at their file and I'll say, well, you have been arrested. Why did you say no? And they'll say, well, we filed something to have that sealed. In their mind, they assumed it automatically would be sealed. How does that work?
So a lot of people, and I get a lot of calls on this for whatever reason, think that if they complete deferred adjudication, that the case automatically falls off their record. That's just not true. You always have to make that next step, and you have to go through with the non-disclosure to seal it from your record. Now, non-disclosure is good if you complete it successfully because it is dismissed right at the end. It is a dismissal, but for that reason, you're not entitled to expunge it. You're only entitled to non-disclosure.
So I've had individuals that have had a charge against them when they were a juvenile. And in Texas, that's under the age of 17. So let's say a 16-year-old had a robbery charge. And in this charge, then they successfully completed whatever the supervision was. In their minds, they have a tendency to think, as soon as I turn 21, this case is going to be dismissed. But that's not necessarily the case. Somebody actually has to file a motion to have that record sealed. I assume non-disclosures have the same idea working behind that.
Right. Yes, Judge. Yes. So there are, the non-disclosure law has went through a lot of changes recently, the most in 2015 and 2017. There is something now called an automatic non-disclosure, but that doesn't mean that it comes automatically off your record. It means that if you file it, the DA really can't oppose it, and it's pretty much just a formality. Nothing in adult criminal world just comes automatically off your record.
You actually got to go hire an attorney, file the case, and have it presented.
Unless you feel like you could do it yourself. And I have heard of people doing that, but I would imagine it's pretty challenging.
I'm sure if somebody goes online, they could pull up a form that, they type in something that says, petition for expunction or whatever it may be called, right? I'm sure people can pull those up online. What's your advice to people that ask you, hey, can I do this myself?
Well, I know that, there are individuals that have to do that. I know that, I want to say the Texas Supreme Court does prescribe some forms, especially for non-disclosures, I want to say, to allow you to try to do that yourself. The only thing I would caution about that, and I understand that maybe some individuals can't afford to hire an attorney for something like this. This isn't something where you'd be entitled to a court-appointed attorney to have it done for you. So I could understand why people would try that, but I guess what I would caution them is that if it's not done properly, and then you're going for a job application or something, and then you think that you can deny it and it hasn't really been done, then you look like a liar. And
that really defeats the purpose, right? But now, DWIs fall under a special exception. How does that work?
So whenever you asked me initially about non-disclosures, I said generally they include deferred adjudications, but and up until I want to say 2017, that was all that they did include. But more recently, they have amended the code to include certain convictions. So even in some situations where you've been convicted of a few misdemeanors, and I believe DWI is one of them, that you can actually also move to have it non-disclosed. Now, I want to say with respect to a DWI conviction and then also deferred adjudication on a DWI, which is a relatively new thing, it can't be any evidence that there was a blood draw result of above 0.15, and there could not be an accident where another individual was injured. And so that's basically the carve out that allows you to be able to get it non-disclosed.
So if you have an accident charged with DWI, maybe part of that accident would be a DWI with an accident or a DWI with an assault or intoxication manslaughter, you really got to get that case completely dismissed before you can ask for any type of relief in the future related to sealing the record or having the record destroyed.
For the most part, I mean, it has to essentially be reduced all the way down to a DWI Class B misdemeanor, which is just a straight regular DWI.
You have any cases that you've had in the past that you could sort of use to illustrate something like that?
Sure. Yes. I recently had a case where I represented this young woman that's recently moved away. I think she lives in Colorado now. But she was a college student at the time. It was a DWI case where there was a very minor accident, but I want to say that maybe the passenger in her car was injured. But for whatever reason, I was able to get the DA to agree to reduce it down to a lesser charge, which was obstruction of a highway. And so she did the deferred adjudication on the obstruction of a highway, and she completed it successfully. And so then after the fact, we waited the 2 years, which is required for an obstruction of a highway for non-disclosure. I filed it, and the DA's office actually opposed it. And the reason that they opposed it was because there was an accident. And we had kind of a back and forth about it because this wasn't a DWI technically. The DA's office had agreed to reduce it to an obstruction of a highway. Their rationale was that, well, in the interest of justice, we're going to oppose it anyway. even though we understand that it was reduced down from a DWI to obstruction. And so that's another way that functions and non-disclosures differ, is that the DA's office and the judge have the ability to deny or not grant the expunction in most cases if they find that it's not in the interest of justice. And so it's not just about checking the boxes of eligibility like an expunction. It is, but you almost also have to prove that they would be a good candidate for it. And a lot of times that has to do with, are they a good person? What have they done since then? Have they graduated school? Are they working? Have they got any criminal cases after the fact that still might be pending? Did they have anything before that maybe wouldn't necessarily exclude them from being able to have it undisclosed, but shows that maybe they wouldn't be a good candidate for this? And in my situation, I was able to successfully get the non-disclosure, but it did take a few hearings in front of one of the judges.
I can imagine, because you have a disposition of a charge when you ask for a non-disclosure, then statute of limitations would not apply.
So, Judge, with respect to non-disclosures, the statute of limitations doesn't really apply as much in this situation because there are prescribed waiting periods in the code after you get off of the deferred adjudication where you have to, before you can ask for the non-disclosure. For any type of felony, it's 5 years. So, I mean, that's actually a pretty long haul. 5 years from the date you get off of the deferred adjudication until you can ask for the non-disclosure. And during that 5 years, you cannot get arrested for any other case, and you cannot have any other certain misdemeanors, certain kind of lifting type cases. You can actually move to have those non-disclosed as soon as you get off probation. And then more serious misdemeanor assaults, DWIs, you have to wait 2 years after the time you get off probation in order to have it sealed.
Well, Rob, you have a lot of experience with these types of cases when it comes to expunctions and non-disclosures. Rob, do you enjoy your work? You enjoy the practice of law, having your own practice and able to basically help people in the way that you do?
I do. I always wanted to have a job in the law where I got to help people. I started out in civil rights, and then I transitioned to criminal defense, and I'm in court every day. I'm the kind of guy that likes to be in court, talking to people, dealing with people. I'm not someone who likes to be kind of stuck behind a desk all day. I'm a pretty active guy. And so